Good afternoon and good morning, wherever you are. Welcome to this special edition, special event organized by Fatherland Group, which is the international law implications of the recent arrests of Nnamdi Kanu in Kenya and Sunday Igboho in the Republic of Benin. You're all very, very welcome. Now, on the 15th of January of this year, the Fatherland Group organized an event, Igbo and Yoruba speaking with one voice. We wanted to help people to make the breakaway from the historic rivalry between these two groups, to get them to understand that the issues that they have in common, that the challenges that they have in common, and the threats that they face are common threats, that their real opposition is not themselves, as they've historically been led to believe, but is coming from outside. Little did we know that matters will come to such a dramatic climax as the arrests of these two leaders of thought. At the very least, you may not agree with their tactics, you may not agree with some of their utterances, but few will deny that they are speaking for a constituency. And that constituency are those who believe that there ought to be another way for Nigeria, that it does not have to be unity by force, that there is room for coexistence of the ethnic groups. Now, the Fatherland Group is essentially an organization, a network of Nigerians across the board, both at home and internationally, whose primary focus has been to educate our people. Wherever there's misunderstanding, we seek to bring understanding. Wherever there's ignorance, we seek to bring knowledge and information. And wherever there's a deficit of education, we seek to plug the gap. And so this event is our another installment in that exercise. One Nigeria is an ideal, and it is all very well. And since 1960, we've been trying to achieve one Nigeria by governance. But the experiments, by popular consensus, the experiment seems to have failed, and failed very dramatically. And it seems that the advocates and the champions of that formula of one Nigeria now wish to achieve it by force. I often use the analogy of the possibilities for union. I use the analogy of the orange and the apple. The union of the orange, where the skin represents Nigeria, and within that skin, you have the segments of the orange representing each of the ethnic groups. Within that formula for Nigeria, the Sunday Igboho, the Yoruba nationalists, could sit side by side with Nnamdi Kanu, the Igbo nationalist, and indeed with President Muhammadu Buhari, the Fulani nationalists. The alternative, which we've been pursuing historically, has been what I've called the union of the apple, which involves the crushing of the ethnic groups such that we become one indistinguishable mass. So when you peel the skin of the apple, you see that mass within. That seems to be the object of the Buhari administration. And when he promised us the next level, this appears to be what he meant. And it's significant that the arrest of Nnamdi Kanu in Kenya was announced on the 29th of June. And you may recall that the assault on Sunday Igboho's house the bloody assault, I should add, was also carried out at 2 a.m. On the 29th of June. Now, one of the lessons we've sought to get across to the public, we in the Fatherland Group, is an understanding of the significance of that date, the 29th, that most, when you look through the chronology and the calendar of events that have occurred in Nigeria, in this long-standing North-South contest, most of those events you'll find have taken place on the 29th of the month, and in particular, the 29th of May. So there was significance when the Buhari administration sought to bag the two voices of dissent, the voices of nationalism in the South, sought to bag the two of them on the same day. Now, our speaker today gave me the advantage of an insight into his papers. And one of the issues that caught my mind was the story of Adolf Eichmann, the Nazi war criminal. That's one of the legal cases he's going to be taking us through. And I was a bit disturbed when I saw that the Supreme Court judgment, I'm not going to actually spoil the narrative for you, but I was a bit disturbed when I saw that the Supreme Court judgment in that case that established the principle of law that Barrister Oladele will be taking us through, the decision was on the 29th of May, 1962. And I thought, well, it seems that the caliphate's reach even extends beyond the Nigeria space. But let me introduce, seriously speaking, let me introduce our speaker today, who is going to take us through the issues. Let me hand over to the person who's leading the discussion, our barrister. And we're proud to have him as a member of the Fatherland Group, Barrister Oladele Osinuga. Over to you, sir.
Thank you very much, Dele, for that kind introduction. I wouldn't call myself an expert in international law. I know I've worked in international law for the last best part of 10 years, but of course, we're here to discuss the implications on the international law, as well as domestic law, on the arrest of Nnamdi Kanu and Chief Sunday Adeyemo, otherwise known as Sunday. Before I comment the organizers for today's conference, I would also like to thank Reverend David Okorojudu for suggesting that we do enlighten the public about the implications under international law of the arrest of Kanu as well as Ugbo. I have a slide which I will share, just to give a perspective and background to the issue we're discussing today. So, international law, as we know, has been in the news, the last couple of years and also the last couple of weeks. We can go as far back as, aftermath of what happened September 9/11, the actions of the United States invading Iraq for the second Iraqi war, which a lot of international law scholars said did not have authority under international law, that was unlawful under the UN Charter, because the United Nations Security Council was giving a mandate for all those countries which prosecuted the war on the first proximity, because there was no basis for invading Iraq based on the allegation that Saddam Hussein had weapons of mass destruction. We can also go back to the invasion of Crimea by Russia, which was contrary to international law, to the Budapest Memorandum, which was an agreement signed by the Western Allied nations, Ukraine and Russia, at the breakup of the Soviet Union, to guarantee Ukraine's territorial integrity. Now, coming close to home, with our leading international law experts, Professor Elias who was Attorney General, later Chief Justice, and also served on the International Court of Justice as the Chief Justice of the International Court, was a proponent of international law, particularly giving legitimacy to international law as a law of nations and how nations govern themselves through treaties, through conventions. In this particular instance, with the arrest of Sunday Igboho and Nnamdi Kanu, certain principles come to mind. We look at extraterritoriality, which basically means that for crimes which are committed in a certain jurisdiction, does that country have a jurisdiction to investigate and prosecute and try persons for crimes in other countries? We're looking at repatriation, which normally happens whenever you have an international humanitarian situation, particularly with the internal displaced peoples, some in Nigeria as a result of the conflict in the northeast part of Nigeria, the Boko Haram conflict. You have people who have been displaced. I mean, they under international law are entitled to protection. Hence, when cases might arise, people might be repatriated to their countries where they originate from, or to have a kind of a safe harbor. In terms of expulsion of citizens, you're looking at where people are subject to immigration rules, where they come under jurisdiction of the national jurisdiction in terms of immigration rules. Are they subject to immigration rules in the country where they reside? And I think I was on extradition, and of course I discussed earlier on international law, as well as national law, and in terms of the rights of fair hearing. These are rights which are guaranteed under national law in all the countries under discussion: Kenya, Benin, Nigeria, of course, United Kingdom, as well as within the African Union judicial framework, particularly with the African Charter of Human and People's Rights. Then we look at the role of Interpol, International Criminal Police Organization. Interpol, contrary to what many believe and might watch in movies, the International Criminal Police Organization is not a law enforcement agent. What the Interpol does is to coordinate. They have a national criminal bureau which coordinates requests from countries, particularly when a red notice alert has been issued, and they then act on the requests with the national authority, competent authority, either the police or any other law enforcement competent authority which is responsible for policing and law enforcement in the party state, in the country which is a member of Interpol. In this case, Benin, Nigeria, Kenya, and of course, Germany or United Kingdom as applicable. So red notices will be issued, and it's available publicly from the research and from the public information we have. Neither Nnamdi Kanu or Chief Sunday Igboho, Adeyemo, otherwise known as Adeyemo, were on the Interpol red notice. There was no notice for them on the Interpol list. And of course, if there was that, then the respective countries would have had to act on it, either through surrender or through the extradition process. Under customary international law, one of the reasons why there is a recognition that states are sovereign nations, that they do not have the right to enforce their laws on territories of other states. Of course, I mean, there's treaty agreements which allow that, and that's fine. Then states enter into agreements with each other to arrest and transmit persons who may be sought under special conditions, which refer to some of the areas we mentioned earlier on, particularly in relation to red notices, where that might be in place. In Kenya, the provisions of the Commonwealth Extradition Act applies. It's a Commonwealth Extradition Act, which is similar to the one we have in Nigeria. It's a 1967 Act, similar to what's in the UK as well, and it's applicable to the extradition of Commonwealth citizens, member of Commonwealth states. And of course, if Nigeria had invoked the provisions of that treaty, then Nnamdi Kanu would have been subjected to the procedure under the, but of course, that wasn't what happened. Of course, the person might waive their right to be extradited. Repatriation, as we said, might be voluntary or on humanitarian grounds as a result of conflict or natural disaster. And of course, we've seen that with the current situation with the pandemic, where countries have repatriated their citizens. Under national law, from what I said earlier on, immigration laws, the person might be subject to an order to be removed. What happened, and that's happened in a number of cases in Nigeria as well. Patrick Wilmot is a famous example of someone who was deported. Of course, that was contrary to laws then, because he was legally resident, but he was deported by the Babangida regime, I believe in 1985, if my memory serves me right. The forceful removal of a person by states or agents acting on their behalf to another is unlawful. I mean, that's guaranteed under the African Charter, right to liberty, fair hearing, right to the truth, prohibition of inhumane and cruel treatment, and of course the principle of non-refoulement under the International Covenant of Civil and Political Rights, as well as the Convention Against Torture and the International Convention on Prohibition and Prevention of Enforced Disappearance. And of course, there was a period of time from the time Nnamdi Kanu was in captivity, from what we know, in Kenya for a week. We could have said he was disappeared because no one knew where he was. And then there's an important principle which Dele Ogun brought up earlier on, which was reaffirmed in the case of Under Heichman, the legal principle of male captus benedentus. Basically, this means person who's been wrongly captured, might have been abducted or kidnapped, that person is properly detained. I mean, there's a presumption in law. But of course, there have been a number of conflicting decisions on that principle. Under the laws of Kenya, section 256 and 259 refers to kidnapping, similar to provisions under our criminal code in Nigeria, as well as section 254 and 257 of the Kenya Procedure Code. And of course, where crimes and similar committed by agents of states from one state to another, that is extraordinary rendition. Of course, it's a transfer without process. The person might be subjected to detention, torture, and interrogation. In this case, in Nnamdi Kanu's case, he was brought back, detained in Kenya for a week, and of course, from what we know, in the custody of the DSS. And from that time, there was effective transfer to the Nigerian state. There are two categories of rendition. One, the first category is state agents, where the person sees, the individual sees, is by one state to another state without using the formal or legal process, the process of extradition, or the person is not subject to immigration control. And then the second category is where that person's seizure is conducted by another agents acting on behalf of a state with the awareness or approval of the state. So in this case, we know that Kenya, as we have seen in other cases, which I will discuss, particularly Abuja Ochulen, and also there's a recent one of Seledin Gulen, we can see that there's an acquiescence by Kenya of the extradition rendition of citizens of other countries from Kenya. Extradition generally occurs where there are existing bilateral and multilateral treaties with other states. Of course, in Nigeria, there is an existing treaty under the Commonwealth Extradition Act. There's also the ECOWAS Extradition Convention, which Nigeria is a party to, and also Republic of Benin is a party to. The famous Lord Denning, in a case of R versus Secretary of State of Home Department ex parte Solon, said every person coming from abroad who sets foot lawfully in this country, that is the UK, is free and he commits no offense, unless if he's not detained or arrested, or if there's no attempt to arrest him in order to surrender him to that country. In the absence of any extradition treaty, it is no answer for the Crown or any other officer of the Crown to say that he wishes to send him off to another country to meet a charge there. It is unlawful, therefore, for the Crown to surrender a fugitive to a foreign country unless it is warranted by an extradition treaty with that country. So, of course, this is what is the kind of a legal principle, and it's even though this is a UK case, it's very much the principle which other countries adopt in terms of extradition. And in this case, Dr. Solen, who was a communist, who was facing the charge of murder. He had been convicted in the United States but escaped. But and in this case, I mean, he had no right to be in the UK. And of course, he was, after a long, drawn-out process, when he was about to be extradited, he actually committed suicide by slashing his wrist and, ingested unlawful and harmful substance, which led to his death. So he wasn't able to be extradited back to the United States. But of course, the principle is clear, as succinctly put by Lord Dele in this case. In Kanu's case, the chronology from what we know so far is that on the 14th of May, he was in Nairobi, where he had an hospital appointment. On the 19th of May, he was allegedly, he was abducted at Nairobi airport, kidnapped and forcibly imprisoned by agents acting for Nigerian and Kenyan authorities in a house in Nairobi. On 27th of June, he was extraordinarily renditioned to Abuja. And of course, we had the announcement on the 29th of June by the Attorney General that Kanu had been intercepted. And of course, I was quite curious when I heard the word interception, because of course, as a lawyer, minister in the Temple of Justice, I mean, interception is not something you use either as a prosecutor or defense in terms of when you are stating a case against someone who is subject to criminal proceedings. And of course, he was rearrested, and Section 31 of the Administration of Criminal Justice Act in Nigeria, if one reads it, the literary interpretation of that provision, it does kind of sanction rendition. But whether the rendition has to be extraordinary, that is a matter of interpretation. And of course, we will see in this discourse. And of course, 28th of June, he was remanded in custody till Monday, where he'll be. IGBOHO'S case, I mean, he wasn't extraordinarily renditioned, but he was, of course, I think either on the 20th or the 21st of July. Interestingly, one of the things we now know about IGBOHO'S case, allegedly, I haven't seen the memo, they said there was a directive from the federal government or from the Department of State Security on the 9th of July, a so-called stop list, which prohibited Mr. IGBOHO from leaving the territory of Nigeria to another country. This, from what I know, and looking at the National Security Agencies Act, there is no basis for this kind of directive in law in Nigeria, both in under national law and under international law, and under, particularly under our constitutions. When we look at Chapter 4, Human Rights Charter under our constitution, and as well as under the African Charter. As of today, we know there's no known charges against Mr. IGBOHO. They're allegations, they're not charges. And according to his lawyer, the interview which his lawyer gave to BBC Yoruba, Professor Salami, his lawyer in Benin, one of his lawyers, he said there are 3 allegations against Sunday IGBOHO. One, allegations of trafficking of arms. The second is incitement to violence. And the third is treasonable felony. And of course, we know they would have to prove this for the extradition of Mr. IGBOHO to succeed, because it would be in breach of Nigeria's commitments under the treaty, which a lot of people have cited, the treaty between Nigeria, Togo, Ghana in 1984, and also the ECOWAS extradition convention of 1994, which, of course, being the latter law, that would be the law which is applicable. In terms of Kanu's case, from what we can gather, the credible source, there is no UK involvement in being a party to the incident. But we can't say the same for Kenya in terms of Nnamdi Kanu, even though Kenya has officially denied the matter through the High Commissioner in Abuja on the 2nd of July. But of course, as we've seen in some of the other cases, we know we can only take Kenya's official denial by face value. And of course, Kanu being a citizen of the United Kingdom, as well as Nigeria, of course, he's publicly renounced his Nigerian citizenship. The Vienna Convention on Consular Relations is applicable, particularly Article 5, where he's allowed, and I know there's been serious challenge to that, and there's been disagreement of the Department of State Security in actually referring his request to the High Commission in Abuja to be of consular assistance during the legal proceedings which he faces in Nigeria. And like I said, the applicability of the ECOWAS Convention, which is the law which is prevailing, and under the ECOWAS Convention extradition, particularly Article 28, it says that where there is to be extradition proceedings, that must be in line with the procedure in that country. And Republic of Benin being a former colony of France, and from my experience with France and similar civil law jurisdiction countries, that has to follow the normal procedure for extradition. Now, the key point here is to look at some of the other cases which we know. It's interestingly, in Nigeria, rendition is not a term used under national law. We're all familiar with the one we talked about earlier on, the case of Adolf Eichmann, which is a 1961 case. And that case involved a Nazi war criminal, as Dele Ogun said earlier on. He was extradited. He wasn't extradited. He was actually abducted in Argentina by Israeli forces. They abducted him, renditioned him to Israel. And when the case against him was brought in Israel, one of the challenges he made was that he was extraordinarily renditioned. And of course, the Israeli courts said that whilst the manner of his arrest might have been unlawful, it is a matter of international law that when it comes to the manner of arrest, that can be raised as an issue in terms of the validity of the proceedings before the courts. And the courts then said that it was that was actually cured because there was an agreement between Argentina and Israel to cure the tort of the illegal abduction of Adolf Eichmann. And of course, this case has been cited, particularly in the United States, in the case of Alvarez Machin, a guy who was accused of killing a DEA agent in Mexico, and then he was then extraordinarily renditioned by the United States law enforcement agencies from Mexico to face trial in the United States. And this case has been cited by United States courts. However, a number of other common law jurisdictions, including the United Kingdom, South Africa, in a number of decisions have actually departed from the position of the Israeli court in the Adolf Eichmann case, as well as the United States Supreme Court in the case of Alvarez and Machin. Of note is the case in the United Kingdom, where a gentleman by the name of, he was from New Zealand, of Bennett. Mr. Bennett was a salesman. He sold a helicopter, but he was accused of false accounting fraud. And then he fled from the UK to South Africa. And in South Africa, he was lured and tricked and entrapped by South African police and handed over to a British police detective. And in that case, when he came to the UK, the charges were brought against him on those grounds of theft and fraud. However, he appealed to the High Court, and then the High Court ruled against him. He then appealed to the House of Lords, and the House of Lords, in their judgment, were of the view that because of the manner of his arrest, it was an abuse of process and the state proceedings against them. When we look at cases in international sphere, we look at there's a case in the International Criminal Tribunal of former Yugoslavia of prosecutor versus Dragulan Nikolic, where the courts said there were 4 elements in terms of rendition. 1, the role played by the executive authorities of the forum states in the transfer of the accused, the nationality of the accused, the role of the injured state, that is the state in which the person's rendition is from, or otherwise their protest. And of course, if they've complied with treaty obligations, and the crime for which the accused is sought. As we've seen in the case of Eichmann, those were serious crimes. And so, of course, there might be justification for that, even though international law tribunals, as well as international law bodies, have ruled against that. And in later case of prosecutor versus Sako Domakovic, the ICTY tribunal departed from the Dragulan Nikolic case, where they said luring is not a violation of a state sovereignty, whereas if the rendition was irregular, that could be a unilateral action, and of course, contrary to international law. We see in the case of in the South African case of Ibrahim, similar again to the Bennett case, where Mr. Ibrahim was abducted by South African police force from Swaziland. The court ruled that the arrest was illegal because South African police did not have authority in Swaziland, and it was necessary to promote human rights, important for good international relations and the healthy administration of justice, so they declined in that case. Furthermore, in 1981, the United Nations Human Rights Committee, the Geneva-based body, declared that rendition of persons to torture was contrary to International Covenant of Civil and Political Rights, particularly Article 9.1. And in that case, a gentleman named Mr. Lopez Burgos, as well as others, were renditioned to Uruguay, and the United Nations Human Rights Committee ruled that compensation should be paid to them and they should be released accordingly. The European Court of Human Rights, which is a leading body for human rights in the world, particularly for the Council of Europe states as opposed to the EU states, in the case of Bozamo versus France, ruled that in this case, Mr. Bozamo was renditioned through the cooperation of Italian and Swiss law enforcement back to France. And the court ruled in that case that whilst they couldn't order the release, he was entitled to compensation of 100,000 French francs and 138 French francs for his legal costs. And there was a violation under Article 5 of the European Convention of Human Rights to the right to the security of a person. When we look at the case of Abdullah Öcalan, that's a case that happened in Kenya. Mr. Öcalan was the leader of the proscribed Turkish People's Liberation Party, the PKK. He initially was expelled in 1999, I believe it was February, from Syria. He was then granted permission to stay in Athens through his contacts with the Greek intelligence authorities. And then Greece then agreed that he be sent. He wasn't deported, but agreed that he be sent to Kenya. When he got to Kenya, he was then kidnapped, of course, with the tactics of Kenyan agents, because they never denied it, by Turkish intelligence and Turkish security forces, where he was then repatriated, renditioned back to Turkey. And on 17th of, in 2003, he then brought a case before the European Court of Human Rights to challenge the action against him by Kenya when he was renditioned. And what the court then ruled in that case, ruling in favor of Mr. Otulan. And again, they couldn't order his release because he had already been tried. There were charges against him in Turkey. Was that the manner in which he was renditioned back to Turkey from Kenya was contrary to the European Convention of Human Rights, and effective control had been given to the state of Turkey from the time Mr. Otulan was apprehended in Kenya. And of course, the court ruled that it was a violation of Article 6, the right to fair trial. It was a violation for his right to have individual application. And it was also a right as there was a lack of effective remedy by Mr. Otulan. The case of Abu Omar is similarly a case which was quite in the news in 2009. And the only reason why we knew about it in 2009, there was the trial of 22 CIA agents by the Italian prosecutors. And from what I know, Italian prosecutors, I mean, who I've dealt with professionally and who I know, they can be fiercely independent and tenacious. And in this case, the allegations was that Abu Omar, a citizen of Egypt who was residing in Italy, he was captured on the 17th of May 2003, renditioned through Germany, and then to Egypt, where he was in custody from the 19th of February 2003 and eventually released on the 17th of February 2007. And what the court then found was that whilst the CIA agents, none of them faced trial because they were all abroad, claimed to have diplomatic immunity and official immunity under the status of forces agreement between Italy and the United States. The court ruled that what they did was kidnapping and extraordinary rendition, and it was outside the realms of what the official duties were under the status of forces agreement, and they could not rely on being immune for their actions. And the court then awarded to Mr. Omar, as well as his widow, a sum of €1 million and 500,000 euros to his spouse. And of course, this case, I mean, was then reaffirmed by the Constitutional Court in Italy, even though the case against the Italian agents who helped them was actually, they were acquitted because the evidence was taken secretly, and the court ruled against that. But the court, Castiglione, and also the Court of Cassation in Italy affirmed the decisions against those who were jailed by the court, sentenced by the court in Italy in the Omar case. What was interesting in that case was that there was one of the agents, Mrs. De Souza, who was a citizen of Portugal, States, to face sentence because there was a European arrest warrant out for her. So invariably, it means recognition was given to that verdict by other European states, and she returned to Italy for a sentence to be commuted by the President of Italy. In the case of Khaled El Masri against Macedonia, Mr. El Masri was kidnapped on the borders between Serbia and former Yugoslav Republic of Macedonia. He was held incommunicado for 3 weeks in a hotel in Skopje, the capital of, and he brought a case against the United States, first Inter-American Human Rights Commission, who then ruled that his case was admissible under the American Declaration of the Rights and Duties of Man. And also he brought a case in the European Court of Human Rights against Macedonia, and on the 13th of December 2012, the European Court of Human Rights ruled that the transfer of Mr. Masri was unlawful, and it amounted to extraordinary rendition. And in fact, in that case, they ruled that it was contrary to the Article 3 of the European Convention of Human Rights provision of torture, Article 5, prohibition against arbitrary detention, and that also it was contrary to the International Convention for the Protection of All Persons from Enforced Disappearance. And Article 5, the right to liberty, as well as security, and of course the failure to investigate on Article 2, on the right to effective remedy. And Fyrom, the former Yugoslav Republic of Macedonia, was ordered to pay 60,000 euros to Mr. El Masri. Whilst the European Court of Human Rights have been quite consistent in their approach when it concerns cases relating to extraordinary rendition, from what we know, when we come to the African human rights system, both the African Commission of Human Rights as well as the African Court have not been favorable. In fact, in the case of Abdullah Saleh Al-Saleh versus Djibouti in 2024, Mr. Al-Saleh was a businessman of Djiboutian origin who was residing in Tanzania where he had his business. He was then renditioned by Djibouti agents back to Djibouti. He was able to describe circumstances of his rendition, including describing that he was there when there was an earthquake around that time. But what the African Commission found out there was he hadn't conclusively substantiated the territorial jurisdiction. That is, he couldn't prove that he was in Djibouti. And of course, it's difficult when in those circumstances, I mean, how could he prove? I mean, there was no manifest. He wasn't voluntary visiting Djibouti, so it was difficult. And even though there was a review of that case before the African Commission, there was no favorable outcome to Mr. Al-Saleh. In the tragic circumstances which we've seen with Kenya, there's a case of Dong Samuel Luak and Agri Idri. Both of them were leading opposition members in South Sudan. And in 2017, the High Court in Nairobi had ruled because the Sudan had sought their extradition and also sought that they leave Kenya, and Kenya had wanted to deport them, but the High Court in Kenya ruled against their deportation. However, they were extraordinary rendition from Kenya to South Sudan, and in 2019, a UN panel reported that it was highly probable that they executed on the orders of the Internal Security Bureau of South Sudan. Now, recently in May, Oladele Gulen, I mean, people might not be familiar with him, but they'll be familiar with the surname, because he's a nephew of Oladele Gulen, who is the exiled spiritual leader, Turkish exiled spiritual leader who's based in the States. Mr. Gulen, his nephew, he lived in Nairobi. Apparently he disappeared beginning of May from the headquarters of the Kenyan Police Service, interestingly. And then weeks later, the end of, I don't know if it's another 29th again, 29th of May. I need to check the dates. It might be 29th again. At the end of May, his wife reported him missing. And then suddenly, all of a sudden, the guy turned up on TV in Istanbul with the Turkish flags behind him in handcuffs, charged with being a member of a terrorist organization, of course, the Gulen organization. And again, in that case, Kenya denied being party to his rendition. They denied any knowledge, despite the fact that the guy was in the Kenyan police custody, and from where he then disappeared and ended up in Istanbul. Now, what are the legal remedies in terms of persons facing extradition, particularly with Nnamdi Kanu? I mean, the chart here shows the chart here is the jurisdiction of the African Court, and also when they talk about the Commission, it's not the African Union Commission, but it's the African Commission of Human and People's Rights, which is a body set up under the African Charter of Human and People's Rights to look at claims and complaints of people who have been aggrieved of rights under the African Charter. Interestingly, when we look at the other regional bodies, including the European Court of Human Rights, including the European Court of the European Commission, and including also the Inter-American Rights Commission, as well as the Stoddard Court and the ECOWAS Court. The African Court does not permit individuals to make applications directly to them. There's a number of procedural hurdles which individuals need to make, particularly that's set out in Article 34(6) of the protocol establishing the court, which should be read in conjunction with Article 5(3) of the same protocol, and also the rules of courts as well. And this can only be invoked where a party state makes that declaration that they are allowing their citizen or an individual to make application before the court. So of course, even for those who are not lawyers, they can see where the challenge is. So it's very, very difficult for persons to raise individual matters before the African court. And in fact, the last time I checked the rules and the last time I checked, only 4 countries allowed such procedure, namely Tanzania, Mali, Malawi, and Burkina Faso, and Ghana as well, 5 countries. So Nigeria is not one of them. And of course, this is not surprising. However, there's also the avenue of raising a complaint directly to the African Commission under Article 56 of the Charter. This is the Charter, the African Charter of Human and People's Rights, which allows persons to raise matters to the Commission. And this, if the Commission makes a finding, then that can then be referred to the courts. But of course, the court is not even inclined to take the application. And as we've seen in the case of our salads, the African Commission of Human and People's Rights has not been favorable when it concerns cases involving extraordinary rendition. Chief Obafemi Awolowo famously said in one of his speeches he gave to the African Organization of African Unity, where he represented Nigeria at some of the conferences, that a commitment to international law is also a commitment to rule of law in a domestic situation. And one question one has to ask is, if Nigeria has not made a commitment to international law, would it be possible to make that same commitment under domestic law? And in fact, whilst our Constitution under Section 19 refers to respect to international law, as well as our treaty obligations, the question to be asked, have we actually respected that? Has the government of Nigeria respected that? And in terms of the domestic remedies available to Mr. Kanu and Sunday Igboho's case being different because he's in the Republic of Benin at the moment, so he can make a claim in the courts in the Republic of Benin and under the extradition procedure. And whilst in the last couple of days, what we know is that the lawyers of Chief Sunday Igboho have actually filed a claim in the High Court for the enforcement of fundamental human rights, particularly in relation to the raid on his dwelling on June 29th of June, under the provision, under the enforcement of fundamental human rights procedure 2009 of the Federal High Court. And that, of course, relies on Chapter 4 of the Nigerian Constitution, which sets out our basic fundamental human rights from Section 33 on. And of course, relies also not just on international law, but also particularly African law, the conventions of ECOWAS, as well as the African Charter of Human and People's Rights. And rendition is not a term, as we know, it's not a term that is normally used domestically. US law refers to rendition as a warrant requesting an extradition of a fugitive from one territory to another. Of course, all the states in the US are different, they're seen as different territories. So if there's a rendition, that's issued under US law, particularly US law 18, chapter 18, section 3182 refers to that. Now, the issue before us is to see whether the rights of Nnamdi Kanu and Chief Sunday Igboho has been violated, and what rights they have under our laws, both under domestic law, international law. And as we've seen, They do have a right to be judged fairly. They have a right to be free to express their convictions, free to express their right to self-determination. And of course, this is the right to self-determination, as we know, is guaranteed under the UN Charter, and it's one which the court has actually reaffirmed in a number of cases, particularly in the case as recently as 2010, the independence by Kosovo, and one which I actually did write a paper on in 2010. And what the court then said was that declaration of independence of people who are seeking those rights to be free from self-subjugation or alien domination, they have the right under international law to declare independence as well as seek self-determination. And this is reaffirming the principles laid down in the case in Western Sahara brought by the Polisario Front, as well as the Namibia case, Southwest Namibia as it then was, where the court then reaffirmed that they had the right to self-determination. Recently, we have seen cases where some of the rogue countries, particularly rogue countries like Iran, Turkey, have used extraordinary rendition, and of course Belarus, as in the case of the gentleman, one of the leaders of the protest movement, who was then forcibly returned back through the hijacking of the plane, because that was state hijacking of the plane, back to the capital of Belarus for him to face trial. There was a recent kidnapping in May, well, attempted kidnapping, which the FBI announced in July, of an Iranian journalist, Mrs. Ali Jannat, who was to be kidnapped by Iranian agents, 4 Iranian agents acting on the authority of the Iranian state. Well, the kidnapping was followed by the FBI, and they're currently facing trial. Then there's also the issue of Mr. Carlos Ghosh, who, as we know, was one of the leading businessmen in the automobile industry. In fact, he was probably the most powerful man in the automobile industry until his fall from grace when he was then arrested. And of course, Carlos Ghosh then escaped from Japan in January 2020. And of course, in the case of self-rendition, because he had complained, and others have complained about the state of justice in Japan, where the rights of accused who are currently facing criminal proceedings are usually not respected, and also contrary to what you would obtain in other countries. In terms of countries actually denying rendition, whilst a lot of countries have actually denied being party to rendition, what we've seen is that even though the countries have not admitted liability, they've actually paid substantial compensation. Countries, including the United Kingdom, particularly for those detained unlawfully in Guantanamo Bay, contrary to international law, Canada, and even Sweden, Norway have paid substantial compensation, as well as Australia, to persons who have been unlawfully renditioned. Now, in terms of looking at this case, we do realize that there are a lot of issues which are currently at stake. And of course, without wanting to prejudge the actions of the court in both Nigeria and the Republic of Benin, what is quite clear is that this is a process which is extrajudicial. It's contrary to international and domestic law. What Nigeria could have sought in the case of Nnamdi Kanu was to have sought an extradition proceedings with Kenya. Of course, if that wasn't going to be granted, that's a different matter entirely, but the process has to be seen through. That's part of the due process. And in the case of Chief Sunday Igboho, we know for certain that there is no existing charge against him. We know for certain that he doesn't have any indictment against him. There's no warrant for his arrest. And a mere directive by the federal government, irrespective of who the ambassador in the Republic of Benin is, does not permit the court to extradite, or the state in the Republic of Benin to extradite Chief Sunday Igboho. In fact, there was a case in 2003 in the Republic of Benin, the case of a gentleman who was allegedly an armed robber, the case of Mr. Halima, who was a Nigerian. He was extradited by Benin to Nigeria outside the process. And what the Constitutional Court in Republic of Benin then ruled in that case was that that was contrary to the Constitution of Benin. It was an undue interference with the administration of justice. And that for a person to be extradited, they had to be conclusive proceedings against that person in their state, that is in the country where the person is from. And without that, you are unable to extradite that person. And from indications from what we've heard, including from leading lawyers in Benin, particularly from what Professor Salami had said, alluded to on the BBC TV, we know that as this instance, there is no case against Chief Igboho. And then, of course, an extradition of Chief Igboho is highly unlikely because there is no case against him, either even in Benin or in Nigeria. So without further ado, I hope I have broadened our understanding of what the issues are. I know international law can sometimes be a mundane subject, but of course it gets interesting because we're talking about the relations between states, state treaty obligations as party to treaties, not just paying lip service to it, as happens sometimes with our government, but also being committed to international law. And of course, when we go back to what happened to someone like Chief Jaja of Opobo, we can say that was probably one of the first known cases of rendition in Nigeria, because King Jaja of Opobo was renditioned, as we all know, in 1886 from his kingdom because he had refused permission for the British to trade in his kingdom, renditioned to Accra, where he stood trial, and then banished and exiled and sentenced St. Vincent and Barbados, and tragically, after serving sentence on his way back to Nigeria, he died. So we can see there's a long history of rendition in Nigeria, and hopefully we want to see an end to that because it's contrary to international law. And as lawyers and also as citizens who believe in the rule of law, we should condemn and criticize such measure. And of course, when an extradition process, in the case of Chief Sunday Igboho, is outside the process, where they want to extradite someone, extraordinary rendition or extraordinary extradition, that should be unlawful. And of course, it is under international as well as domestic law. Thank you.
Thank you so much, Barrister Dele Osinuga, for the light that you've shared and you've shed on these murky affairs. If I could invite you to stop sharing your screen. But let me summarize what I picked up. There is a law of nations. Nations are also supposed to be law-abiding. And this is the essence of international law. And it makes sense. When the state is the ultimate enforcer of its domestic laws, how can it be that when it comes across its borders, it can now conduct itself with lawlessness? And the fundamental right, we're told, is the right to a fair hearing that's guaranteed by all countries. We were told that Interpol, its role is to coordinate requests from countries for assistance. But it is a process. A red notice is issued and Interpol responds to that red notice. We were informed that neither in the case of Nnamdi Kanu nor in the case of Sunday Igboho had Interpol been asked to issue red notices. This was the state acting without regard to avenues which were open. How desperate, how threatening are these two gentlemen to the interests of the Nigerian state, to go to the extreme of bypassing available channels, using the established avenues of Interpol to arrest them, if indeed they deserved arrest. When a state abandons such conventional and legitimate channels, one then begins to suspect the agenda of that state, that this is political rather than criminal. We heard that states are sovereign, and as a result, no state has a right to go and cross the boundaries of another in order to enforce its laws. Even when we watch American movies, even at that level of states in America, we see how fugitives, in inverted commas, once they cross the state boundary, the states within America, the law enforcement agents have to go through proper processes to have that the fugitive from justice to be picked up in the proper way. They don't drive across the boundaries and pursue them regardless. We heard that there is a Commonwealth Extradition Act. And so Kenya is part of the Commonwealth. Why did the Nigerian government not use that avenue to apprehend and arrest Kanu and to bring him back? We as citizens, there are times when we feel that we have rights or we have an interest in assets which have been perhaps wrongly taken away from us. But we go through the law process, we go through the courts, we go through proper channels to retrieve what we believe to be ours by right. How much more when it comes to the custody of an individual, a human being, that a state can simply cross the lines and grab them. When we're not talking about Adolf Eichmann, neither of these two individuals have killed anybody to my knowledge. So where is the parallel? Where is the line to be drawn? One can understand that there will be occasions where the individual in question his conduct has been so heinous that the state can take shortcuts or will take shortcuts. But this is not the case in either the instances that we are concerned with. We heard the principle that emerged from the Adolf Eichmann case, that a kidnapped person is properly detained, that it doesn't matter how the state got hold of him. Once he's brought into the jurisdiction, then that does not violate the internal process. But we also heard that principle has been refined. And we would like to think that our government belongs amongst the collection of civilized states that will conduct themselves properly. We heard about the Dele judgment, that even in the case of a visitor to Britain, that the state has no rights and cannot simply hand them over to a pursuing state without due process. And one of the classic extradition cases that's in Hansard was actually concerned the Nigerian government back shortly after independence, when they sought to extradite the late, great Chief Anthony Enahoro, one of the classics in the Hansard reports. Proper processes. We are now in 2021 and we've gone seriously backwards when we will ignore available channels and simply take what we want. How does a state convey the message to its own citizens that you simply cannot bypass due process, bypass legal channels, bypass the courts in order to get satisfaction on your grievance, when the state itself is engaging in kidnapping actions. We heard that a stop notice was purportedly issued in respect of Sunday Igboho, prohibiting him from leaving the country. But it was questioned as to what process was gone through and whether that is indeed the case, and especially in circumstances where he has not been charged with any offense. How do you prohibit somebody from leaving the country in circumstances where he has not been charged? One lesson that came through was avoid Kenya. It seems that all the cases that were mentioned, Kenya was coming up again and again and again. Kenya should be off our visiting list for all Nigerians. Whether you've done anything wrong or not, stay away from Kenya seems to be the lesson, and pass the message on to other countries or citizens of Africa. Boycott Kenya, stay away from it. He touched on an issue that I'm particularly interested in. The suggestion that Nnamdi Kanu has dual citizenship. He traveled on a British passport, and by birth, he was a Nigerian citizen. But I put the emphasis on the word was, because it begs the question, what does an individual have to do? And this is a question for Barrister Dele Osinuga. What does an individual have to do to renounce the citizenship of a state? Yes, you were born as a Nigerian, but you don't want to be a Nigerian any longer. And if anybody made it clear that he does not wish to be a Nigerian, that individual was Nnamdi Kanu. He called the place a zoo. He does not want to belong to a zoo. And he had made a public and clear, unequivocal declaration that he resents everything that Nigeria stands for. So any suggestion that he was a dual citizen seems to me mistaken. I wonder if Dele will comment on that when I return the microphone to him. He had only one citizenship, in my view, and that was the citizenship of Great Britain, which then begs the question, what responsibilities does Great Britain have to its citizens? If Nnamdi Kanu was an Englishman from Yorkshire, saying exactly the same things about Nigeria, would the British government not have acted in these circumstances? What does British citizenship mean if the leader of a state, and ironically, this particular leader has passed through? We know that the efforts that he made to kidnap Umaru Dikko in his first outing, he now seems to have graduated, at least perfected the strategy. So there's one thing he can boast of, doing better second time round than he did first time round, which is the art of kidnapping. But does the British government simply stand back when a serial violator of the rights of bearers of its passport? What is the responsibility of the British government in these circumstances? What does that passport, what rights does it confer beyond simply passing through the airports whenever we travel? We heard about the European Court of Human Rights, but of course we know that Brexit has happened. I wonder if Dele could comment on that, because if Britain had still been a member of the European Union, Nnamdi Kanu would have had access to the European Court of Human Rights. And my suspicion is that that was one of the key calculations on the part of the British establishment. They were concerned about access to the European Court of Human Rights. And Brexit, although it was not voiced as one of the considerations, but from the reports that I was reading and the discussions I was reading, I know that they were very resentful of being subject to the standards being imposed by the European Court of Human Rights. Again, Dele may touch on that when we return the microphone to him. Well, those were the key issues. And finally, he did affirm that, confirm that the right of self-determination is affirmed by the United Nations. It is a right. If people want to self-determine, it is their right to agitate for it, to campaign for it. And these two have done nothing more, especially when we consider the provocations that the Nigerian state has allowed to happen. Without those provocations, we would not be where we are. Where Fulani, I don't call them herdsmen, Fulani armed men have been allowed to invade our fatherlands, our respective fatherlands, and conduct themselves with impunity. It's like a visitor walking into your home and putting his feet on your chair as if it belonged to him, no longer a visitor. Is this what One Nigeria really entails, that we should submit to such impunity? And that when people speak out and speak up against such conduct, that they would then be pursued as if they had been convicted murderers. These are the issues. Now, we will come back to, Dele has taken note of my shopping list of questions, but let's hear, I can see Chris Maduka. Let me hand the mic across. There was a question that he had raised, and I think he can articulate it better than I can. And whilst we look for Simon Munzu. Over to you, Chris. I'll give you 5 minutes.
Okay. Thank you very much, Dele. You've done a great job in putting everything in perspective and putting it on the front burner. Nothing could be more rewarding and patriotic than to speak up when it matters, stand up for justice, and to unite the people. You know, those are just the basics. Now, the issue I touched upon, I thank the legal expert, Barrister Osinuga, for really doing an extraordinary job in touching all those areas. But the one that caught my attention was the Alvarez-Michan case in Mexico, whereby the DEA actually paid the bounty hunters. They put out what looked like some of what the northern guys put out. They put out a bounty and reward on Alvarez-Michan. And these guys went and seized him in his office, injected him, and flew into El Paso in Texas, the border town between Mexico and Texas. And then the U.S. authorities assumed custody and jurisdiction. In that particular case, the U.S. District Court ruled in favor of Alvarez that he should be returned to Mexico. And the appeal court did the same, but the Supreme Court, which was headed by late Justice Rehnquist, did something that was so extraordinary, and a lot of people kicked against it, including the European Union and other people, when they did exactly what the barrister touched upon by saying, yes, that they agreed to the treaty and the law that specifies how different nations can obtain each other's citizens. But then he went on what seemed to be very weird, that those things did not specifically exclude what happened in Alvarez Michan case. In other words, no matter how he got to the jurisdiction, they have assumed the right to try him. And what that means is that the doctrine of speciality, which is available to somebody given the extradition treaty opportunity, is gone. That's another form of injustice that must be raised in Nnamdi Kanu's case. And also, I want the lawyer to touch on the issue of what they call in diplomatic circle the provisional arrest warrant, which requires, even if they choose to cooperate, the Kenyan government or the people seeking for Nnamdi Kanu must serve his warrant of arrest to the demanding nation. And the diplomatic or the embassies will look at it and see if it's worth the trouble. None of this is all of these are out of the window by breaking the law. So I just want him to look into all these things going forward, because the wrong language is already being used by people that are supposed to know better. They call it extradition, they call it arrest, they say he invaded, he jumped bail. They're not talking about the extraordinary situation that warranted him to run for his life. So I want all these things to come into context as we go forward. Thank you very much, Dele. Thank you, Barrister, for your extraordinary contribution.
Chris, thank you for that. Let's hand back, if you can mute yourself, Chris, let's hand back to Barrister Dele Osinuga. You've got your shopping list of questions. Go ahead.
Thank you very much, Chris, for bringing that case up, the Alvarez case, which I think was wrongly decided. And I think you've explained everything in both in your question and also your analysis, particularly the district court and the court of the U.S. Court of Appeals decision in that case, which was then overruled by the Supreme Court. And of course, that's why Alvarez is not really precedent, even in a lot of common law jurisdictions. In the Bennett case, it was quite clear that they disregarded Alvarez. In the South African case, Ibrahim case, there's also a couple of cases in New Zealand and Australia where Alvarez has been disregarded. So it's not, and even when you look at the Eichmann case, which Alvarez relied on, that was cured because there was an agreement between Argentina and Israel to cure the thought of the abduction of Dr. Eichmann. So, of course, I think, and correct what you said, Alvarez was wrongly decided, and it's not precedent. And even international courts, because I did refer to decisions of the international criminal, former international courts of the former Yugoslavia, the ICTY, where they ruled on the issue of rendition. And they actually were quite clear as well that even where rendition is permitted, I mean, it must meet certain standards. And those were issues which were decided in the court in those two cases which I mentioned, the Nikolic case and the other matter. So it's quite clear under international law what the status of rendition is. And if you do recall, the Inter-American Judicial Committee, which is separate from the Inter-American Human Rights Commission, similar body, both of the OAS, Organization of American States, they actually ruled that the decision in the Alvarez case was unlawful and contrary to international law. And again, the Human Rights Committee have been quite unequivocal in their condemnation of extraordinary rendition, particularly as being contrary to the International Covenant of Civil and Political Rights. Now to the questions which Dele has raised. I think the issue of the European Court of Human Rights, and this is a distinction which unfortunately Dele being a senior lawyer, which sometimes it's a genuine mistake. I know a lot of people make that mistake as well. As we know, because there's been talk of the current conservative government in the United Kingdom reviewing treaty obligations under the Convention of European Human Rights, which is a separate body from the EU. So if Kanu was to bring a case where he feels that the UK have violated his rights under the convention, he's still able to bring it because the UK is still a member of the Council of Europe, because the European Convention of Human Rights is actually a Council of Europe treaty, which the UK is a treaty to. And what the Labour government then did under Tony Blair was to then bring the Human Rights Act to enshrine the provisions of the European Convention of Human Rights into domestic legislation. So which then meant that you could rely on the convention in courts in UK rather than going to Strasbourg. Of course, you can still go to Strasbourg if you exhaust domestic remedies. But the court has said even you don't have to exhaust domestic remedies before bringing a case, which is contrary to the precedent set in the law of the African Commission of Human Rights, as well as African courts. There has to be, but in the case of the European Court of Human Rights, you don't even have to exhaust domestic remedies before bringing a case to the European Court in Strasbourg, which of course is separate. And again, this is where it gets interesting. There's also the European Court of Justice, which is the judicial arm of the European Commission. And of course, UK no longer being a member of the EU is no longer party to that. So of course, we're not subject to the ECJ, which is separate from the European Court of Human Rights. Both similar courts, and of course, the ECJ, interestingly, also has a mandate to look at human rights, both under the convention and also under the Treaty of Rome and the subsequent treaties establishing the European Commission. Now, to look at the issue of citizenship of Nnamdi Kanu, he's under the laws of Nigeria. He's a citizen of Nigeria because the process for renounced citizenship has not been effected, even though I know he's publicly renounced it. But under the laws of Nigeria, both Immigration Act, as well as under our constitution, he's still a citizen of Nigeria. It's not enough to renounce it, but the official process has to be invoked for him to renounce the citizenship of Nigeria. So, but UK still has an obligation to him because he's a citizen of the United Kingdom. And the main treaty provision for that is the Vienna Convention on Consular Relations, particularly Article 5, which basically means that he's entitled to consular assistance by the British High Commission in Nigeria for the time for the process and the procedure which is currently going through the criminal proceedings against him in the Federal High Court in Abuja. In relation to the assault on IGBOHO'S house, I mean, we all know, I mean, that happened again on the 29th of June. And from what we know, Chief Sunday IGBOHO is not facing, even though there is the issue of the so-called letter written to the DSS, a so-called letter preventing him, prohibiting him from leaving the shores of Nigeria, but that letter has no effect in law. I see there is also another question which relates to whether the federal government had availed the public of crimes. Of course not. I mean, in case of Kanu, it's slightly different because we know the charges against Nnamdi Kanu. I mean, there was a case against him before he left Nigeria. But as Chris rightly said, it had to have gone through the due process. There had to have been a formal extradition request from Nigeria to Kenya to seek the extradition of Kanu rather than the extraordinary rendition. And I do agree with Tunde Adele, who then refers to the whether Nigeria would accede to the request of the federal government of Nigeria. It hasn't followed due process. Of course not. They would not accede to that request because, as we know from indications from what we've heard, both under Benin law as well as under international law, particularly the multilateral treaty signed between Nigeria, Togo, Ghana, and the Republic of Benin, and as of course the latter ECOWAS Convention on Extradition of 1994, there is no way Mr. Chief Sunday IGBOHO will be extradited to Nigeria without that following the due process, and that's particularly clear in the provisions of those treaties as well as the convention. I think I've answered the questions, Dele, unless of course the other. I think is there anything I left out?
Yes, you've answered them very well, but there are more questions here and others on its way. Just pressing you on this issue of Kanu's renunciation of his citizenship. Your answer was that notwithstanding his public utterances. He's done everything within his power to say that I'm not a citizen of that country. If I've understood your answer correctly, he still has to submit himself to the processes of that country which he rejects in order to get out of its citizenship. Even in circumstances where those procedures, and I think you're referring to what is called the 1999 Constitution, even though he will say that that document had no input from me or my representatives. It was an imposition. So why should I have to submit myself to something that somebody drafted in the comfort of the closet with him and his mates in terms of how I get out of citizenship when I and my people were not reflected and represented in the making? Would an international court not accept that he's not a citizen, regardless of what the Nigerian government may say? Would an international court not accept that in those circumstances he is not a citizen of that country and does not have to go through whatever the 1999 document may say to renounce the imposed citizenship? Could you deal with that?
Well, of course, under international law, I mean, one can't be stateless. I mean, there's actually a UN convention on that. And of course, we know he has British citizenship. He doesn't have to subject himself to the process. But there is a process under Nigerian law, both under the Constitution of 1999 and also under Nationality and Immigration Act, where, and other than the government stripping someone of citizenship in Nigeria, it's not a process that has been tested, really, to my knowledge, of someone being stripped of their citizenship in Nigeria. I mean, simply renouncing it, for all intents and purposes, under our laws, is not sufficient. I mean, it has to go through the normal process. But that has to be tested, of course, in the court of law. I mean, maybe he has to file a declaration in court of law and say, well, I'm hereby declaring I'm no longer a citizen of Nigeria. That might suffice. But of course, it's not just stating it, but there has to be a process under the law for him to then be, for his citizenship to then be renounced and then perfected, and then he's no longer a citizen of Nigeria.
Well, staying on that issue, a question has just come up from Mr. Dayo Fadina, who I know to be an immigration law expert. He's asked a question. In Kanu's case, could his British citizenship trump his Nigerian citizenship?
Well, I think Dayo he's probably the best person to answer that question, isn't it? Well, would it? Not to my knowledge, because of course, I mean, if you're a citizen, if you're a dual citizen, I mean, there are even people that have citizens of 3 countries. None trumps the other. I mean, both are, I mean, you're both citizens of both countries. Of course, in terms of, we know in the real politic world, when you're using a passport, there's one passport is more powerful than another, to look at it that way. But legally, I don't think it's a British citizenship trumps the Nigerian citizen. They're both equal. I mean, he's a citizen, he has equal rights under the laws of both countries. And in terms of the hierarchy, I mean, both are equal to each other, even under international law. But of course, we know in terms of practice, practicality and our day-to-day lives, we know which one is actually much more kind of more superior or more influential than the other one.
Thank you for that answer. Moving on to the distinction, and you rightly corrected me, distinction between the European Court of Justice and the European Court of Human Rights, that notwithstanding Brexit, Britain remains subject to the European Court of Human Rights. What it has escaped from is the European Court of Justice. Now, I'm curious as to if in somebody in Nnamdi Kanu's situation, I focus on him because he holds the British passport. Although I believe Sunday Igboho also holds a British passport. So the issue is relevant to both of them.
No, I'll just clarify something with Chief Igboho. No, he's got German nationality, German citizenship, residency, not citizenship. His wife is a German national, of course, of Nigerian origin. So he's got German residency, not citizenship. His lawyer clarified that. His Bene lawyer, Professor Salami, did clarify that.
Right, thank you for that. Now, Justice had thrown in a question, which I read as follows, because it ties into this issue. Nnamdi Kanu, a British citizen, was abducted and taken to another country where he alleges that he's been tortured with restricted access to medical care in breach of his fundamental human rights. Are there grounds to challenge the breach of his human rights in the UK courts or in the European Court of Human Rights or the European Court of Justice?
Right. In terms of the European Court of Justice, there'll be no grounds because we're no longer a member state of the European Union. In terms of the European Court of Human Rights, one would have, and as well as, of course, in the UK courts, one would have to establish that there is a link, a credible link, not just very credible, highly, it could be circumstantial, but highly credible link that Britain was a party to his extraordinary rendition from Kenya to Nigeria. And of course, as we can see in the Abdullah Öcalan case, the European Court of Human Rights was quite clear that from the time Kenyan authorities had given effective control to Turkey of the abduction of Abdullah Öcalan, they had effective control. And remember, that happened all in Kenya. It didn't happen in Turkey. I mean, even though some of the allegations related to what happened in Turkey, subsequent to that, and of course, in relation to the trial, but majority of the allegations of the complaint of Abdullah Öcalan happened in Kenya. So, of course, if there is a credible link and substantial evidence to suggest that the UK did play a part in assisting Nigeria, then, of course, he can bring a claim either in the High Court or at Strasbourg at the European Court of Human Rights for violation of his rights under the European Convention of Human Rights.
And what about my question, which is perhaps not so much a legal question as a political question? If Nnamdi Kanu had been from Portsmouth, a son of the soil, what could we have expected to have happened in the same circumstances?
Well, as we know, I mean, we need not even look back further. I mean, we know, even for those of us who are British citizens, either, British citizen by birth or British citizen from someone who's lived in the UK from the time they were a toddler. We do know, unfortunately, and I think it's the history of colonialism, that there are different categories categories, inverted commas, of citizens in Nigeria. The Begum case is a classic example where someone was stripped of their citizenship because they were married or allegedly took part in terrorist activities in Syria. And this person was alleged to have been a citizen also of Bangladesh. She's never even visited Bangladesh before. And in that case, I mean, a lot of people condemned it. I mean, the case is still ongoing. That how can you strip someone of their citizenship where they've been born in that country? So in terms of if, say, Kanu was someone from Portsmouth or someone from Yorkshire with no roots at all in Nigeria, whilst the UK, the UK would still demand that Nigeria, accedes to its responsibilities under the Vienna Convention on consular relations. Other than that, I mean, and raising the dramatic protest, I mean, worst case scenario, we'll call the ambassador, the High Commissioner. There's not much the UK would have been able to do. I mean, they will use diplomatic pressures and, to try and see if they could release Nnamdi Kanu to go through the normal process of extradition. But other than that, there is nothing the UK could have done. And again, it also depends on the individual as well, not just the fact that the person might be from Yorkshire or Portsmouth, but you know how valued is the person to the country. They might think that, well, this person is someone who might cause us a lot of trouble. Then it's dispensable. Or of course, if a person is of high value, then they might raise a further protest and then say, well, if X does not happen, then we're going to do Y. So it really depends on the circumstances of the case.
Thank you very much. I take from that if
I hope that's answered it.
Very much so. The lesson that I take from that is make sure your children are playing for the England football team. Then that may raise your value to the Foreign Office if the Nigerian government was to get hold of you. But if they don't have skin in the game, you'll probably be out there on your own. Thank you very much. Now, you've been performing for the last hour and a half. Unless there are any other pressing questions, then I think we can say thank you for a real education. This is what the Fatherland Group is about. It is about shedding light. Philip F. Young has come in with a comment saying, I appreciate the legal details and technicalities that have been eloquently shared regarding Nnamdi Kanu's arrest. However, can we address the human and non-technical issues that are of concern to most conscientious Nigerians and humanitarians? Let the laws be applied as long as they are applied broadly and equitably to everyone, not just certain individuals, activists, and ethnic groups. When will arrests be made of armed Fulani murderers who have unleashed massive destruction on several communities? If government can flirt with the idea of rehabilitating Boko Haram assassins, is it too much to at least consider dialoguing with Kanu rather than always resorting to aggressive measures against him? How much punishment has been meted out to the Abacha family for the millions they stole, regardless of the alleged recovery of some of the loot? Now, that requires no elaboration from me. It speaks to the very heart of the issue. If we are supposed to be all Nigerians, it cannot be acceptable to have a state of affairs where some are roaming the land as if in Animal Farm, that some animals are more equal than others. And then when those who perceive themselves to be more equal than others go about murdering, raping, pillaging, and generally conducting themselves with the utmost disregard of the rights of others, can it be reasonable for the state to then descend on those innocents, those victims, to then use its coercive powers against them? That's the point that Philip F. Young has raised. And we all know the answer. All decent Nigerians know the answer to that. And we must raise the standards of governance to the level of the decent Nigerians and not to take it down to the level of the animals who wish to behave any which way they can, simply because they carry AK-47s and the others don't. It's a point that I hope will get across to those in Abuja, those in authority. Chris has raised his hand. Chris, over to you. Go ahead.
Okay. I just wanted to run this by the barrister. I know he must be exhausted talking for over an hour now. I just wanted to know, let's put aside whatever charges, and let's even assume that Nnamdi Kanu is not even a British citizen, just a Nigerian married to his wife with a British, with a son or children that are British citizens. I know that in the case of Sowore, his wife, who happens to be an American citizen, was able to petition to the senator in charge of his of our area, and he truly intervened, and he made a lot of difference. I wonder if there's anything, maybe you can educate us on that, that the wife or on behalf of the children who are still very young can do. Is there anything they can do, putting aside all the brouhaha about the citizenship, dual citizenship, and other charges? Is there anything they can do to seek for maybe a husband and maybe a Nigerian and maybe a British citizen? I don't know if the question is clear.
No, it was clear, Chris. Thank you very much. They can, of course. I mean, they can raise the issue. Nnamdi Kanu's wife can actually raise the issue with her member of parliament in the UK. She can also raise the issue also with a senator and the reps member for the district, either both from her district, if they're from the same area in Nigeria, both from the same district, as well as Nnamdi Kanu's senatorial and House of Representatives district as well. And of course, also even in the case of Chief Sunday Igboho as well, his wife can raise that with our federal member of parliament in Germany, as well as her House of Reps member in Nigeria and senator or senatorial district.
Thank you very much. I think it applies to both of them, both Sunday Igboho and
absolutely.
Igboho.
Absolutely.
And, yes, I think it applies, and I think they should pursue that immediately, especially in the case of Sunday Igboho, which kind of more frivolous. Thank you very much. I appreciate that.
Again, thank you very much on behalf of all of us, Barrister Dele Osinuga, for that excellent education on the issues, the legal issues arising from the arrest, in inverted commas, of both Sunday Igboho and Nnamdi Kanu. If there's one thing that's positive that's come out of this terrible exercise, this exercise that's covered no Nigerian in any merits whatsoever, it is that the Igbo and the Yoruba are at last speaking with one voice. We were almost prophetic when we organized the event on the 15th of January, where we reviewed the history of the relationship between our great peoples. And we dug into the artificiality of the hatred and how this has been sponsored. So if there's any positive that's come out of it, that's from what Buhari has done. He has brought us closer together than ever before. Made clear by his, I touched on this earlier, by his attempt to punch with both fists on the same day, the 29th of June, trying to catch both of them in the net. These ones were simply speaking the despair and the frustration of their peoples. We are a people when we can feel each other's pain. And right now, Igbo and Yoruba are feeling each other's pain. And of course, it's not just them. Fatherland goes beyond the Igbo and the Yoruba relationship, but we just recognize that that one was pivotal to the all oppressed Nigerians, all Nigerians who are feeling the heat and feeling the boot of oppression, to come together and to put things right and to stand up to the bullies. And it is they say that democracy works well when we can accept governance from each other's hands. And we have to ask ourselves, can the Igbos accept governance from Fulani hands at the present time, given the conduct of General Buhari? Is it fair to expect the Yoruba to accept governance from Fulani hands? Again, for the same reasons. We must ask ourselves these questions and stop blaming the victims. Because when the victims react, all Nigerians want to be good neighbors. They want the best for each other and for their children. But if any group feels that only they are entitled to what is good, and all others must accept whatever they choose to concede to them, let them know that certainly in the Fatherland Group, we will not be quiet. We will shed the lights where the light needs to be shed, so our people can be freed from this reign of darkness. I want to thank everybody, and especially our Superman, Mr. Boniuba, who makes all these things possible, the master of the technology. I want to thank again Barrister Dele Osinuga for his presentation. I want to thank Reverend David Okorodudu for instigating this exercise. I've seen a few more comments. Let me just quickly mention them, the ones worthy of mention. Yes, Ayo Ani, I can't see his full name here. It says, Ayo Ani Fowoshe. It says, yeah, I got it. Food for thought from Philip Effiong, not to be ignored. Absolutely. And Philip Effiong adds, might I add that the rest of us are feeling the pains of the Igbos and the Yorubas. We also are hurting. And so true. So true. As I said, it's not just an Igbo and Yoruba thing. The establishment have clearly decided to pick on the biggest of the biggest units in the South, but as a lesson to everybody else, with a view to trying to silence them and intimidate them. But we will not be intimidated. Cecilia Lewis, Buhari is not a terrorist. He said it immediately he came into power. He can afford to be reckless. He needs no one's vote. Nobody pay attention to that statement. Yeah, I get the sense of what you're saying, Cecilia. We allowed ourselves to be deceived. We allowed ourselves to be deceived. I don't blame him. I don't blame him. We chose to cover our nose when we decided that we were going to return him to power. Hopefully the lessons are learned for 2023, that your votes is powerful. You cloak them with legitimacy. And I would say enough of cloaking them with legitimacy, because they will turn around and say, but you voted for us. All the warning signs are there for 2023 that these guys are not going to play by the rules, that this is not democracy as we're led to believe. And if we choose to play along with them, then we will have ourselves to blame. It is, Richard George says, it's collateral damage on all sides. No one comes out of this as a victor. It's divisive and will take me generations to heal these fault lines. Thanks, Fatherland, again, as ever, for putting up a fabulous, educative and insightful session. Now we speak based on facts. Too right. Well, before any more of you get carried away with excellent comments that forces me to carry on this session, I'm going to sign off. See you at our next event. Sign up to our newsletter on the Fatherland website, fatherlandgroup.org. Together we will beat the enemies of light and the forces of darkness. Our eyes are now open. Let's keep it open. Thank you very much. Have a good night.